Hello, this is Bronson with Miller & Company Property Management, back with another short video. This one will be about evictions. Now luckily, with a great tenant screening process, evictions are rarely necessary anymore. But occasionally, we will either get a property with a tenant that wasn't screened by us, or very rarely, there could be circumstances that turned a great tenant into somebody that we may have to evict. This is very rare. Just a small fraction of 1% of the time, but if this does happen, we usually like to do anything we can to repair the problem. But in some circumstances, we're left with no other option. In these cases, it's very important to follow the law exactly, so there's no room for the case to be dismissed or for a countersuit to be filed. Okay, so I'll go over the steps with you now. The first thing that we would do is to post a 3-day notice, either to pay and or to comply with the terms of the lease, depending on the situation. If the tenant does not pay, comply, or move out within 3 days of this notice being posted, then we can terminate their lease and file an eviction. Some other reasons a landlord can evict would be if the tenant is maintaining an illegal business at the property, committing a crime at the property, damaging the property, or creating a nuisance, although this last particular one can be very tough and is only recommended if there are multiple police reports or corroborating witnesses to back it up, and no better option to use. With all of these examples, we can actually just give a 3-day notice to quit, which doesn't give them an option to correct the situation, but only to move or be evicted. In Utah, an eviction is called an unlawful detainer. Once the 3-day notice is up and the unlawful detainer is filed, the court will schedule a hearing within 10 days. The court will deliver a summons to the tenants, letting them know when and where to appear, and if they'd like to contest the accusations. If they do show up and contest, this can add to the total time of the eviction, but as long as you follow all the rules, Utah law allows landlords to recover attorney's fees once they win the lawsuit. Once you win, you can apply for a writ of restitution from the court. This will direct the tenant to vacate the premises within 3 days or less. This will be served to the tenants along with a blank request for a hearing. If the tenant does not request a hearing and does not vacate the premises, then the writ of restitution allows a sheriff or constable to forcefully remove the evictees. Now, the tenant may arrange to get their belongings within 5 days of the removal free of charge. If they don't get them, they can still get them within the next 10 days once they pay for the moving and the storage of the items. After 15 days, if the tenant has made no reasonable effort to reclaim their belongings, and if no hearing about their belongings disposition is scheduled, the landlord may sell, donate, or dispose of the property. During this time, you can either have it moved to a storage facility so you can start working on the property, or you can just start getting the exterior stuff worked out and schedule everything else, and then when the time is up, you can get everything moved out and get started on the interior. All in all, Utah strongly favors landlords, and evictions usually only take 11 to 28 days. So that should do it for evictions. If you have any questions about this topic or anything else, feel free to give us a call. Thanks for watching and have a great day.